over 6 months. So they've sent me a fine of over $1,000 because I think the fine was about $600 at first, and then they double it each time. So I sent the fine back with all the writing that you suggested, and we'll have a look at that in a moment. And then they came back a couple of days ago with a demand for double the amount again, so over $2,000 now. So this time I wrote them a letter, and I also sent the demand back by registered mail this time. The first time I just sent it in an ordinary envelope because I figured they get all this registered mail, they just chuck it away. But actually now they have to sign for this one. So I paid for the post office to get a signature.
We've been doing that here in New South Wales too, and it's gotten so prolific for them receiving these remittances and that registered mail is not even being collected anymore. It's been totally ignored. Some of the registered stuff's been 3 weeks waiting, and when you look up the registration number for the delivery, it records as undelivered. So when you ring up the post office saying, well, where's it gone? And they investigate it, they go, well, it's arrived at the address, but no one's collected it. And I think that's because those people have been flagged. So any mail that's sitting in that box just gets left there. It's disgraceful what they're doing.
It is, and it won't help them because what we're doing is totally illegal. And I'd like to share the screen. Yeah. And let's go and have a look at, first of all, the letter that I sent to Spur. So they wrote to me and said that I had written an online inquiry. I hadn't. So I did not submit an online inquiry. I advised you by letter to pay the overdue fines using money from the trust in the name of Michael Thomas Holt, of whom I am the equitable beneficial named estate trust title holder. Now, for the viewers, I will make a template of this letter available on the common law website. I think it's on your page already, isn't it, Michael?
Yes, I think so, yeah.
Yes, okay. So when you go onto the website, commonlaw.earth, just go to Resources Document Library.
It's just a disclaimer. The remittance program that we're using is above board. It is fully lawful. It is subject to the bills of exchange. The bill of exchange is actually the process or procedure. We're using it as a procedural document. So you will receive pushback on it by GovCorp. And keep in mind, that's because they have been frauding us virtually since 1901 to make us believe, they've brainwashed us through our schooling, through our adulthood, everything, that they know better than we do. Everything they say, that we have an obligation to follow their orders and obey them to the letter. And every time we don't, all of a sudden there's threat, there's enforcement, which is deemed as extortion. And this is all they have.
Ask the questions?
Yes. And that's all they have. They have to force us to do it. And if we don't comply as their slave, then they come with these heavy penalties, thinking it's going to scare us into cowering and doing what they say. But if you stick to your guns, it will pay off down the long run. Just have fun with it. Yeah, it can be stressful for some. Some people don't understand enough. So halfway through, they cower and they pay their bill. Well, there's nothing wrong with that either. You're not doing anything wrong paying the bill. You're just out of pocket when you shouldn't be.
That's right.
If you can afford it, go for it. If you have a use for a license, especially for commerce use, then, you know, I understand that, yeah, you pay the fine, don't fight it. But at the end of the day, every fine issued under the Bill of Rights, 1688, Section 12, all fines and forfeitures being the threat of cancellation of licenses and things like that, are null and void prior to a conviction.
Yes.
Everything they're doing is illegal, it's unlawful, and then you just have to keep that at the top of your mind.
Well, we have to stick to the law and apply it in our dealings with them.
Yeah. What they're doing is an illegal adjudication, because Spur, Revenue New South Wales, all these collection agencies have no authority to behave as a judiciary. They have no jurisdiction to do it.
And well, that goes for the whole darn government. It's a corporation and it's not our Commonwealth of Australia.
That's right.
Yeah. All right. So let's have a look at the letter that I sent to Spur.
Yeah.
You can see here that, first of all, said that thank you for your online inquiry. I never bothered going online to inquire about anything. I sent them back their first fine demand, and I told them to put this information here onto the demand, which means they are now able to pay the remittance out of my trust, my
Yep.
CQV trust.
Yep.
Okay, so you'll find this on our website at CIR Now, and you'll also see the videos that we've made before about this. Now, in the letter I go on, Spur must have records of the court listing and why it was referred to your corporation, because strictly speaking, if they're going to send demands like this for a fine to be paid, there must have been a conviction. Where is the conviction?
That's right.
So
Yep.
I'm telling them I've not received any such correspondence. It's logical to assume that they would have provided details of this enforcement when initiating it with your corporation. So why aren't you doing your job?
That's right.
You have not provided any proof of the court record. Therefore, you must either supply me with the record, or it appears you are making a fraudulent statement or obfuscating the situation. 3, if you are denying my payment, you have no further claim, and therefore no lawful or legal right to demand further payment. I have not contracted with you. There is no bilateral signed agreement between us that you can demand money with menace from me, whilst at the same time refusing to honour my payment as directed by me, the equitable beneficial named estate trust title holder. Now, what that means is that I am the beneficiary of the CQV trust, which was assigned to me when I was born. And there's a lot of money in there. I know it's in the billions of dollars now because I looked it up, which is funny because I'm poor.
The sad part is no one is poor. The CQV trusts are there for everybody on the planet, that we all have one. And we got more than enough money there to house ourselves, to feed ourselves, to pay our bills and all that. So there's no reason why anyone should be poor. They are making us poor. Their whole program by design is to waste more and more of our hard-earned savings on shit that's already been paid for.
Yeah, but it doesn't matter because eventually when we hold them accountable, all of this will come back to us.
Yes.
So let's go on with the letter. Now, this is the important part. Increasing the amount each time you send another demand is a crime. Under the Bills of Exchange Act 1909, Section 22, definitions and requisites of acceptance, which states, 1, the acceptance of a bill is the signification by the drawee of his or her assent to the order of the drawer. In other words, they are asking me to draw the money. Number 2, an acceptance is invalid unless it complies with the following conditions. A, it must be written on the bill and signed by the drawee. Well, I wrote on the bill up here, remember, all of this, and I signed it.
That's right.
And I told them, take the money. That's the amount due.
Yep.
And the mere signature of the drawee without additional words is sufficient. But I told them precisely what to do, didn't I?
Yeah, that's right.
Right. And B, it must not express that the drawee will perform his or her promise by any other means than the payment of money. What does that mean, Michael?
Must not access the drawee. So it means that bill of exchange, or that bill, has a dollar amount. It's fixed. For example, if it was $100, you can't be making a claim for $200 expecting them to refund you the $100 difference. It's not going to work that way. So it has to be, because once you've signed it, it's legal tender. It's a dollar note of that dollar amount. It's like you got a $50 note in your wallet, or a $10 note, or a $5 note. That note is fixed to that dollar value, that dollar amount. And that's the same with these. This is a legal tender. This is the same as having a dollar note equivalent to the dollar amount on your bill in your pocket.
Right. And it's actually in the form of a check. When they send you the fine, the first 1/3 of the front page looks like a check.
Yeah, it is actually a check. That's why it says you only need your signature. You don't really need all the wording.
No.
And the beauty is, one of my members followed the program. They got their bill back with a non-negotiable stamp on it. They thought at that end, by putting a non-negotiable stamp on it, means that they're telling the beneficiary that by returning the bill with that stamp on it, it's non-negotiable, implying that he still has to pay out of his own pocket to pay it. What do you have on a check? Non-negotiable when you sign it?
No, they're not too smart, are they?
Because they don't know. They honestly don't know the law.
No.
They're breaking the law, trying to make us believe that we're the ones getting it wrong, when they're the ones committing the crime of fraud, money laundering, extortion. They're actually committing offences against the Commonwealth. We're the Commonwealth. And they're committing these crimes against us, and they think they're going to get away with it.
Yeah. We'll talk about how that's working out for them later on.
Yeah.
But let's just go back to the letter again.
Yeah.
So then I go on and tell them that I have previously fulfilled these conditions. It was written on and signed by myself.
Yep.
And if you are refusing payment to resolve this issue, you are in breach of the law and the Constitution. They've forgotten that they are also part of the Constitution. Clause 5.
We are in equity here, which doesn't really apply with the Constitution. We're talking equity law, which is common law. So it's all common law. The only part the Constitution would play a part in this is the fact that GovCorp are not recognised as a Commonwealth entity. Even in their own legislation, they refer to themselves as non-Commonwealth body corporate entity. And they very specifically state in there as well that the non-Commonwealth body corporate entity is not part of the Commonwealth. That's in their own Act of 20.
That's all very well, because strictly speaking, they're correct. They are a corporation, and a corporation is an entity.
Yeah.
It is not human.
And they're not part of the Commonwealth.
No, but the people who work in there are part of the Commonwealth, whether they like it or not, and therefore they are directly accountable for their actions.
Yeah, as members of their trust or their corporation, or as persons, as their employees are persons, they fall under that legislation. They have to obey by it. But you and I, as Commonwealth nationals, with absolute protection under the jurisdiction of the Crown and the common law of England, those legislations don't apply to us.
No.
And they only apply if we consent and have a contract with it. And in most cases, 99.99% of the time, no one has a contract with GovCorp about anything. No. It was all produced by coercion, deception, fraud, without full disclosure. And anyone who understands commercial contracting knows that there must be a wet ink signature by both parties, bilateral approval, consent on a contract. And they don't have any of this stuff.
That's right. And the thing is, with the contract law, if there is any coercion, or one side of the people doing the agreement are not informed correctly, then the contract is null and void. So if they have a contract with us, somehow, it's null and void because we're being coerced.
It's the same with these fines. They're all threatened and enforced. By default, they're null and void. You don't have to pay any attention to them. Sure, they're going to go ahead and start threatening more letters and then summon you to a court. And if you don't appear in court, they're going to hold court in your absence. There are laws against that.
Yeah.
And you don't have to abide by any of it. And you react accordingly as the situation arises. We in New South Wales are starting to get a lot of fines cancelled because we followed the remittance program. And then after the second notice, which is a reminder, it's the one we wait for because that's got all the criminality written right through it. Then rather than wait to be summoned to court, we then choose to go to court.
Yeah, and that's it.
Yeah.
So the Currency Exchange Act 1965, Section 19 states, for the purpose of making in the currency provided for by the Act a payment, A, that is payable in pursuance of, under, or by virtue of a sale or a security for money, or any other contract, agreement, deed, instrument, transaction, dealing, matter, or made, executed, entered into, or done in pursuance of Section 1 of Section 18, and that I is made by a bill of exchange or a promissory note. Well, we have that.
How are they going to argue that? It's in law.
So therefore, the payment has been made by acceptance of the document sent to you by registered mail.
Yep.
Okay.
Yep.
When you go onto the commonlaw.earth website, click on Resources, Document Library, and that then brings you to this page here. And if you scroll down here to
infringements, where you got that letter, you can post that straight in anyway, because that's really the only letter you really need.
Okay.
Except for the demonstration one, where it shows a sample fine with it on and also the instructions for it. I'll send you that as well. So those two are pretty much the only ones you really need to go in.
I put that in the article already, didn't I?
Yeah, well, you did put it in the article. Yeah, actually. Yeah.
All right, I want to share the screen again now. Let's go back to the law. The Bills of Exchange Act. There we go. Michael, there should be some more information there in the Bills of Exchange Act. I think that would be very interesting for people to understand. And this will also be an exercise in showing the viewers how to read the law. So I'm going to share the screen here. Now, to find the Bills of Exchange Act, I did a search for Bills of Exchange Act. I got this.
Yep.
So let's have a look at the first part. What's the most important part here to start looking at?
We'll start going to numbers. So number 5.
Number 5, application of rules, bankruptcy and common law. The rules in bankruptcy relating to bills of exchange, checks and promissory notes shall continue to apply thereto, notwithstanding anything in this act contained. So if you're bankrupt, you still are bound by this bill.
That's correct. And that applies too, because the country is bankrupt, just like in America. It's why we don't have gold-backed currency.
And B, number 2, the rules of common law, including the law merchant, save insofar as they are inconsistent with the express provisions of this Act, shall continue to apply to bills of exchange, cheques and promissory notes. Michael, would you like to tell us about that?
Well, it means common law supersedes all legislation. So regardless of what, say, for Spur or Revenue New South Wales claim as not acceptable as a method of payment, it's a load of crock.
Very good.
Because it's saying that under common law, the bills of exchange supersede when it's not inconsistent. When it's not consistent, or when it is inconsistent, then the common law rule applies, which is the bill of exchange. And that means that our remittance has to be accepted as a method of payment, regardless of whether they like it or not.
Hoist by their own petard.
Yeah. Okay,
Right.
Next one. Next one would be section 22.
Right. Definition and requisites of acceptance. 1, the acceptance of a bill is the significant, we already read this, right? On the letter.
That's sorry, that is in your letter. Yes, correct. Yeah. Okay, we can leave that out. We'll go to section 26.
26, delivery.
Yeah. Delivery. Number 1 is every contract on a bill, whether it be the drawers, the acceptors, or an endorsers, is incomplete and revocable until delivery of the instrument in order to give effect thereof. In other words, they received the bill, they confirm they received the bill, because when they reply back saying they can't accept it as a method of payment, that tells you they received the bill.
Absolutely.
Well, it's been delivered, they've got it, it's paid. Provided that where an acceptance is written on a bill, remember the acceptance, meaning our remittance is actually the acceptance that we received the bill that they produced and sent to us. We've written on it and we send it back. And the drawer gives notice to or according to the directions of the person entitled to the bill that he or she had accepted it, the acceptance then becomes complete and irrevocable. That's exactly what our remittance is saying. Please take this and accept and balance the account out. 2 is as between immediate parties and as regards a remote party other than a holder in due course, the delivery, A, in order to be effectual, must be made either by or under the authority of the party drawing, accepting, or endorsing, as the case may be. B is may be shown to have been conditional or for a special purpose only and not for the purposes of transferring the property to the bill. Basically, that sums up what we're doing anyway. So the fact that they hold on to the express trust contract and not return it to you means they've accepted the conditions of it. Mm. But if the bill in the hands of a holder in due course, a valid delivery of the bill by all parties prior to him or her, so as to make them liable to him or her, is conclusively presumed. Where a bill is no longer in the possession of a party who has signed it as a drawer, acceptor, or endorser, a valid and unconditional delivery by him or her is presumed until the contrary. So in other words, we signed it, we accepted the condition, the contract, we signed it, put our remittance on it, returned it. So there's no contrary to be proved. They kept it.
And if they come back and say, oh, we didn't get it, or we're not processing it or whatever, then you ask them to return the bill, right?
Return the original wet ink copy.
Right.
All right. Don't accept anything else. Don't accept an attachment on an email and them saying, oh, here's your bill back. Or when they repost it, when they post it back to you and you can see that it's not the original one. That's counterfeit. They're passing off a counterfeit as the original. They're committing a crime.
Yeah.
So if they can't return the original, and we know they can't, we know how the system works. We even had, in my own personal dealing with a CTP insurer, they admitted twice. We destroy them 2 days after receiving them. That was their excuse for not returning the wet ink signature. And my reply back was, since when do you destroy legal tender? That's like having a bucket full of notes, $50 notes, and throwing it on a fire. Who does that? We know exactly what they did. They securitized it and sold it on to be used as a mutual fund on the stock exchange. It's been traded. So if someone's bought it from them as a piece of security to buy and to sell on, that means that person actually paid your debt out. There's no debt to be paid. So why they keep coming back saying, oh, we don't accept that as a method of payment. We still expect you to pay by your credit card, FPOS card, electronic fund transfer. That's a lie.
Yeah.
That's a major fraud. And every insurance company, every bank, every GovCorp agency, like utilities, like phone, electricity, water, they're all agencies of the government. They're not separate. They're all operating under legislation and license by GovCorp. So they're only shop fronts of GovCorp.
And let's not forget that we're still dealing with human beings and ultimately they are responsible.
Yep. They are, yeah, that's right. They're actually unwittingly, they're actually committing a crime. They can be held accountable in their private capacity.
Yeah. And that's what we will do.
Yeah. Yeah. And you can call those individuals to court. If it goes to court, you can call them as a witness. They're the ones that blocked your payment.
Well, the problem is, though, of course, when they deal with you, they don't tell you who they are. They don't sign it. They don't give you their name. Who the hell are we dealing with?
It's important people realise that, especially when you look at the fine, there's no name. There's no man or woman name. There's no one addressed on it. There's no signature. A lot of these reply letters they get from the Revenue Estate Service, it usually just says the Director of Fines or something. There's no actual name. There's no signature on it. So those notices and letters under law, under contract law, have no validity. There's nothing. They're null and void. If you can't speak to another man or woman within that organisation, then you're not talking to anyone. The paperwork they're sending you is of equal value to toilet paper. That's it.
Yeah, exactly. All right, let's go on and have a look at the rest of the Bills of Exchange Act.
Yep.
What's the next one, mate?
The next one would be number 30.
Number 30. Now, the people watching this video can see how easy it is to find the law.
Yeah.
And there it is there.
You just have to read.
Yeah.
Some of it's really short, like this one.
Right. Procuration signatures. A signature by procuration operates as notice that the agent has but a limited authority to sign, and the principal is only bound by such signature if the agent in so signing was acting within the actual limits of his or her authority.
Yeah.
Who's got the authority here, Michael?
The beneficiary is the one that has to sign. We're the agent of the trust that they build. If you look at a bill, it's your actual trust identification on there. The addressee is to the trust. You're the beneficiary. He just happens to be at the same address. So you sign it, you return it. So as the agent, that's exactly what you've done. They can't deny you haven't because you have. They received it. They acknowledged it.
Because they're responding to it.
Yeah, that's right. They're replying back saying, oh, we can't accept this method of payment. We only accept credit card and everything. Well, they obviously received it. Otherwise, they wouldn't be coming back asking for a different method of payment.
All right, let's go on then.
And number 34.
Number 34, holder in due course.
Yes.
A holder in due course is a holder who has taken a bill, complete and regular on the face of it, under the following conditions, namely A, that he or she became the holder of it before it was overdue and without notice that it had been previously dishonoured if such was the fact, and B, that he or she took the bill in good faith and for value, and that at the time of the bill was negotiated to him or her, he or she had no notice or any defect in the title of the person who negotiated it. Would you like to explain that, Michael?
Yeah, I'll use it as a real life example for, again, with the fines. You always get issued your first fine, which is a penalty notice, threatening, demanding that you pay. There'll be an enforcement fee if you don't pay it. And then you get a second one, which is the reminder notice. And then at that stage, when you receive the reminder one, you decide to go back to the first penalty notice, do your remittance, and send it to them. That's a valid case. Even though the first notice might have been overdue, the fact that you did put the remittance on there and actually returned it to them. And that's the first one is the one you do it to, because that's the bond. When you sign, you've created a legal tender. You've created a currency note. That's what they call a bond. Mm. That bond can't be duplicated. It can't be replicated. In other words, like I had in my own personal experience, again with an insurance company, said that because they refused to accept the first one, they said they were more than happy to reissue me a new copy. Well, that's counterfeit. They're reissuing a counterfeit note. And I said, I don't want to be party to your fraud. Stop trying to coerce me into committing a crime with you. I'm only the beneficiary. You're sending it to the trust. I've signed it and I've returned it. If you don't like the original bill, give me back the original copy, the wet signature copy. That's all you've got to do. It's not that bloody difficult. And they don't do it because they can't. They don't have hold of it anymore.
Right.
And that's pretty much the gist of that particular one. You're never too late to act because you've taken it on faith. People don't go away on holidays for 4 weeks. They get back home and there's a bill in there. It's already overdue. I get reminder notices from council regarding my rate notices that it's overdue for payment. Well, I've sent them the remittance. That's paid. There's nothing more to discuss.
All right. What's the next one, mate?
That's pretty much the main ones. There's a library of all acts and legislations. It would take you a lifetime to read every single one. You don't have to do that. The ones that we're referring to in these videos and that, and Mike's doing on his website and that, we're pointing you to the specific acts and specific passages within those acts. And they're the ones you have to learn. They're the ones you keep record of in your own library, because they're the ones you only have to refer to whenever you reply to these GovCorp organisations.
Thank you very much for that. Now, you've been having some pretty good successes down in New South Wales and up here in Queensland. Can you tell us about that?
Yeah. Back in the early days with the People's Trust, they were formed so that there was a set procedure to follow regarding the initial penalty being noticed, being sent to the trust for the trust to handle as the power of attorney. We generally sent out a letter which had 3 questions in it. It was 1 page. There was nothing fancy. It was really just so we rebutted the fine. Otherwise, silence is consent. So we just sent the letter there as 3 questions, asking them to reply. They never reply. They never answer those questions. No. 28 days later, they sent a reminder. We always waited for. The 3rd letter was usually the threatening letter, and they changed it from statute to a criminal act.
That's right.
Paying the
yeah,
fine.
I remember on my fine, it was legislative. It was a legislative fine.
Yeah, it's legislative. And usually on the 3rd letter, they used to claim that it was a criminal act. It was criminal not to pay, and you would be penalised statutory fines.
Good luck with that.
Yeah. So the practice was, when we got to that point, we would then say, let's do a court. Or if it was severe enough, Spiros had the time and energy at that time to actually coach people how to argue in court. They've since changed their system. They've adapted to what we've been doing. And it took us a little bit of while to work out, to find the problems. They're probably enjoying watching this video so they can now sit down and work out how to readapt.
Well, how are they going to get around the law?
Yeah,
that's the thing. They are breaking the law.
Yeah. So what we found was after the second one, the reminder penalty notice, we go straight in and ask for a court. We go in first before we're summoned. So we don't ignore, we go in first, summoned. What we found is that they will send a letter confirming that we've chosen to go to court, and there's a statutory deck form that they send you to fill out. Well, we handwrite that. As living men can only handwrite.
That's right.
We handwrite that out and we send it back. Now we're getting no replies back saying the ticket's been cancelled. So, and there's no court or nothing. So
you're just not getting any response?
Well, no, they do actually reply, and they actually notify us that the fine is being cancelled. and there's no court.
They actually tell you that.
Yeah.
Good.
We got some strange letters. We did get some strange letters first, even when we replied to the reminder notice. They admit in their own roundabout way, because they don't want to be held accountable for what they did. They're trying to backtrack a little bit in the letters, but there's still one passage at the bottom of the letter is always, but we suggest you should still pay the fine. They're inviting you to pay,
Please,
not demanding.
please.
And the rest of the letter above it is all about, we have considered, we reviewed the situation, and we consider that the fine's not applicable, for whatever bullshit reason they got. But the paragraph at the bottom before they sign off, which they don't actually sign off by hand, it's just a print. They still encourage you to pay it.
You're getting a lot of successes with this, I assume. Have you had any failures?
Well, it depends what you see a failure. We've had a lot of people before this. This is relatively new. We've had the last, I'm not fully aware at what time everybody's been doing it. So I can't say the time frame would be the last 4 or the last 5 we've been successful, because those last 4 or 5 could have been a batch of the last 50 who all had different results because they didn't follow exactly. They didn't actually apply for court. They waited until they were summoned to court. But even those individuals who were summoned to court didn't bother turning up. They sent my template letter the notice of a special visit to court and affidavit. They've been sending that in. And because it asked the court to give them 2 days' notice that the court will be ready for them to appear under special conditions as a living man. And the fact that they do that means, well, there's nothing to turn up for. They'll hold the court in your absence regardless. But even holding court in your absence is actually unlawful. Their own acts say this. Our own acts, our royal assented acts actually say this. So we have that to fall back on. So we can ignore when we get in the mail your court costs. Just put a remittance on it and send it back.
All right. Now, what about other things like rates and insurance and things like that?
Same process with the I've got my rates with my local council. I've issued them a response today. Actually, they sent me a reminder and I'll have a quick read of it. It was just a quick SMS. I don't like dealing with them, but being the council and who they are, I couldn't really give a two-hoot. So they've reminded, the standard text was a courtesy reminder. Your Penrith City Council rates are overdue for an amount of $403.60. Reply yes for an extension to pay by the 30th of June, or to make payment now, phone, and there's different phone numbers and stuff like that. So I text back, already paid, bill of exchange remittance returned to you. And then another message I went, refuse for cause without dishonour, remit all debts to the Crown. And then I put in there a little carrot for them to learn the bit. Local Government Act 1993, section 555, 1A. All New South Welshmen should look at this. Queensland has their own local government act, and they need to read that as well, because you have that exemption in there as well. And that explains the refuse for cause without dishonour and remit all debts to the Crown. So under New South Wales, with the local act, section 555, 1A, exemption. If you read that line, it explains why I am exempt from any taxes that the council push on. And then I also included as an attachment, the letter, the Freedom of Information from the governors, confirming that councils have no government authority. They're nobody, they're not recognised. And then I also added after that, I am only the equitable beneficial named estate trust title holder, not the trustee. So just in those 4 messages, plus the attachment of the FOI, they should be leaving me alone. If they don't, they're just criminals. It's the only logical conclusion anyone can draw on, and that's committing an offence against the Commonwealth. And we being the Commonwealth, as per the preamble in our Constitution, they're trespassing on us. They're demanding money with menace.
Yep. All right, mate. Thank you very much. And as always, you've got a wealth of knowledge there, and I thank you for sharing it with everybody.
It's all right. Appreciate that. Thank you.
Thank you. Bye now.
If you're enjoying these podcasts on the bloodyausiebattler.com, why not become a member to support my work?